We'll officially call the Judiciary, Finance, and Policy Committee to order. Today is Tuesday, March 5th of 2013. We don't yet have a quorum. Members, I've asked Representative Cornish if he'd be willing to go first while we wait for a quorum. Representative Cornish. Members, this bill will be going to the General Register. That will be the motion after we have a quorum. So, Representative Cornish.
Well, Madam Chair and members, good afternoon. I'm here today to present House File 161, and on a brief layman's description of the bill I'll give you, and then I'll turn it over to my testifier, Leslie Nibby Johnson, and her daughter Emily. And if you want to set that right up on here, I can. This bill will concern the murder of the man you see, my friend and Leslie's brother, by his wife a couple of years ago. And what happened, I'll let Leslie tell the majority of the story, but a brief description. The reason for the bill is what this family went through after the murder. The person that murdered James or Jim Nibby is in prison now at the Shakopee Women's Prison. I don't know if we're going to do a visit there this year, but we might see her there. What happened after the murder was a trail of tears. Basically, for 2 years, Leslie and her family tried to get back property that went in different directions that she'll tell you about, and they weren't able to put a hold on the property, and it cost them a lot of money and time. And this bill, what it does, it doesn't contain a fiscal note. It's permissive. It's not a mandate, but it would allow a judge to enforce an order. The petitioner could come to the court in the future, somebody like what happened to Leslie, and come to the court and ask the judge to make an order to put a hold on the property so that it didn't go anywhere. And this would have to be after the person is charged with a crime, not just reasonable suspicion, but they would have to get charged. And then the judge could allow even that defendant until they were proven guilty. If they wanted to use some of the property or some of the money, the judge could allow that so that they could, because naturally they would be innocent until proven guilty. So basically what the bill does is allow the judge to step in and say, until this is all settled, the property isn't going anywhere, and so that it doesn't disappear, so that on a final judgment, families like the Nibby family could get back some of the property. Now, if it's okay with you, or if it's okay, I take questions after Leslie's testimony?
Yes, but I'm going to officially call the meeting to order. And Representative Cornish moves that House File 161 be recommended to pass and be sent to the General Register. Representative Cornish, please continue with your testifiers.
Okay, Madam Chair and members, I would introduce my testifier, Leslie Nibby Johnson, who is from the same area that I'm in, and her daughter Emily, to talk to you today.
Welcome to the committee. Please state your name for the record and go ahead.
Leslie Johnson. As Tony said, my brother was James Nibby. He was murdered by his wife on August 31st, 2010, while he was sleeping. She was arrested 10 days later, and she confessed within 24 hours of being arrested. However, for the next 2 years, she tried to take back that confession and tried to get out of being sent to prison. Finally, in July of 2012, she pled guilty and was finally sent to prison. 3 days after her arrest, when she had her arraignment hearing, my family attended that hearing, and her father was there also. We were told of her confession that day, and we had asked her father for some of my brother's personal things, his clothing, his golf clubs, his watch, things that were sentimental to us. He initially said, no problem, give me a list, I'll show it to my daughter, and if she agrees, I'll turn it over to you. 2 years later, 4 court orders, $20,000. I can't even estimate the hours of time that I've taken off of work. We still didn't have those things. We tried to get his golf clubs for a golf tournament that we hold every year to raise money for a scholarship that I created in his name. Her dad wouldn't even borrow them to us. It's been 3 years of golf tournaments. I have yet to put those on my cart when we golf. My brother Jason hunts with my brother Jim. They kept all of their hunting items together. My brother Jason called her father and said, "I'd like to pick up my duck decoys. It's duck opener." And her father said, "I'm sorry, Jason. The morning that your brother was murdered, all of those things became hers, and unless you have a receipt proving that they're yours, I can't turn them over to you." We witnessed destruction of property. In August, after she was convicted, I finally got a court order, the first court order, to go after the property of my brother. When I got to my brother's house, there was a burn pile, and some of the things that had been on the list that I had given to her father 2 years ago were on that burn pile. He had listed some of the things as garbage, and he had told his attorney, "Why would we even want them? They were garbage. I burned them." It shouldn't be up to her family to decide that. I applied for PR-ship of his estate almost immediately. I had people calling me. The funeral home, number one, wanted to know who was going to be paid. The bank was calling me. Bills needed to be paid, and my hands were tied. I could not be named PR of his estate because she blocked me from jail, asking her dad to be PR of his estate, which we refused to, so his estate sat in limbo for 2 years. Finally, in July, when she was sent to prison and stripped of her rights, then I was able to be named PR. I went through the process of 4 court orders. Her dad was never held accountable for any of those things. And in December, I finally signed an agreement. I still don't have things that were on that list. My father passed away 53 weeks to the day of Jim's murder. Never got any of Jim's stuff back. Never saw her go to prison. And we didn't have things that would provide closure to my family at that time. I'm asking that you help me help other families in my brother's name to put a stop to this. These things would have prevented my family from the added agony that we were forced to go through.
Questions from members? Seeing none, is there anyone in the audience who wishes to testify for or against this bill? Seeing none, Representative Cornish renews his motion that House File 161 be recommended to pass and be sent to the General Register. All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Thank you, Representative Cornish.
Thank you, Madam Chair, members.
Thank you all.
Thank you. Is Representative Hansen here? Representative Hansen. The chair moves that House File 136 be recommended to pass and be sent to the General Register. Representative Hansen, please go ahead.
Thank you, Madam Chair and members of the committee. House File 136 is a bill that adds, let me just back up. I've introduced this bill in 2 prior sessions. This bill brings county commissioners and members of the judiciary into the definition of public official. And for the Judiciary Committee, I'm aware that and understand that the Judiciary does have their judicial standards process, but my purpose for including them in the definition of public official is so that we have the same consistency as you and I have as members of the legislature. If you look at the list of the bill, we have appointed positions and we have elected positions that serve as public officials. And as public officials, then they fill out the financial disclosure form, the same form that you and I fill out. We require that of elected folks. We require it of appointed folks, but we don't require it for members of the judiciary. Again, I understand that they have their forms that are public data, but are not in the same database. They are not the same details. And I think there is a value in consistency for elected officials to have this material showing the assets, just like you and I do on the Campaign Finance Board disclosure, so members of the public can see that, just like they can see members of the legislature or members of the appointed bodies that are listed in this bill. I know there's controversy about this, but my understanding is there is an amendment. The Campaign Finance Board would like to make some comments. But my understanding that Judiciary is neutral on this bill.
Questions from members? Representative Hansen, do you know already what disclosures are currently made and what difference this disclosure would be, or is there someone that can speak to that?
I believe there's someone that...
Please come to the table, state your name for the record. And go ahead.
Madam Chair, members, thank you. My name is Gary Goldsmith, and I'm the Executive Director of the Minnesota Campaign Finance and Public Disclosure Board. The board actually talked about this bill this morning, and if I might inquire, Madam Chair, is there going to be an amendment, do you know?
I can't answer that, so please state. Please go ahead.
The board is concerned about adding judges to the Chapter 10A provisions regarding statements of economic interest. This addition would result in a duplication of regulations applicable to judges. It would result in a duplication of agency jurisdiction. And when you have those kinds of duplications, confusion and inconsistent results can be the result of that kind of legislation. The board considered this morning at their meeting. It was coincidental that they were having a meeting this morning. And by unanimous vote, the board opposes addition of judges to the economic interest disclosure program. I mentioned that there's a duplication of regulations. The judges are already bound by the Code of Judicial Conduct, and actually that code is a lot more stringent than the regulations that are placed on public and local officials under Chapter 10A. Judges, for example, and I'm reading from the code, a judge may not hold any position as an employee in any company other than being a judge, except for some limited opportunities in the judge's or family's own small, closely held corporation. Judges can't represent people before agencies or boards as other public officials can do. Judges do file financial statements, although I will say I'm not expert on that because I haven't reviewed exactly what they are, but because most of what judges would disclose under Chapter 10A is actually prohibited, the statement would be fairly limited even if it were filed under Chapter 10A. And those statements are filed with the court. They are public, although I believe they're probably not published on a website like ours are. I mentioned there'd also be a duplication of agency jurisdiction because we have a Board of Judicial Standards. That board is already tasked with applying to judges the standards for their conduct. A judge cannot participate in any activity whatsoever that will interfere with the proper performance of the judge's judicial duties. And a judge cannot participate in any activity that would even allow a reasonable person to conclude that the judge's independence, integrity, or impartiality have been undermined. And these are things from the Code of Judicial Conduct. The Judicial Standards Board has been around for a long time and has experience and expertise in enforcing this code. That's their job. And to place on the Campaign Finance Board some similar but yet different set of regulations and disclosure provisions, and then task the Campaign Finance Board with enforcing those provisions will lead, as I said, to a duplication of effort and potentially inconsistent results. Finally, making a person a public official doesn't just mean that they file a statement of economic interest. It means that if they find that they have a conflict, then they have to take certain steps, file a notice, and if they don't file, and possibly recuse themselves. If they don't file that notice, and somebody believes they should have, they would file a complaint with the Campaign Finance Board. And my board is very skeptical about getting involved in determining whether a judge, in ruling on a motion from the bench, or directing a verdict, or taking some formal action in the context of a trial, has a conflict or not. It's a little different ruling on matters that come before the legislature and typical public officials who take votes on things. The courtroom scenario is quite different. And so for that reason, our board has directed me to voice its opposition to adding judges to the Campaign Finance Board's statute.
Questions from members? Representative Johnson.
Thank you, Madam Chair. And to the testifier, Mr. Goldsmith.
Yep.
You didn't address, I don't think, unless I missed it, the county commissioner aspect. What was your...
Madam Chair, Representative, the board has a lot of experience with economic interest statements and conflict of interest for elected officials whose duties typically result in voting on things. And while there would be some financial repercussions for that, they would be limited. It will be difficult unless the board is fully funded, but we think the legislature is likely to provide us full funding. So we do not, as a matter of principle, oppose adding county commissioners.
Okay, thank you.
Representative Hansen.
Madam Chair, if I could maybe just highlight a response to the
Please
Campaign
do,
Finance
Representative.
Board. So Mr. Goldsmith indicated the judicial standards and the conduct, and that's what's in the existing statute relating to the judges. What the public official and daylighting the economic interests, that's a little different than describing the potential for conduct. So Mr. Goldsmith is correct where you've got a judge that has to make sure that they're handling themselves properly through the standards of judicial conduct. But what we do as elected officials is, and through the filing the economic interest statement, is make public our economic interests. Now, he mentioned that they can't be employed, but they can own property. Think about the questions that we respond to. We have to list our property that we own, we have to list our financial assets, and we have to list whether or not we're involved in parimutuel activities. Those are different than conduct. So I think that this is almost a trust and verify type of thing, where the daylight, by having the economic interest disclosure there, is something that the public can see. The judges are elected officials. The issue of determining whether they're in conflict, you have a process just like other elected officials and appointed public officials to go through there. So Mr. Goldsmith and I disagree on kind of that, whether this is duplicative or not. I think they actually complement each other. I understand that the judicial standards are a bar that judges should hold themselves to.
Representative Moline.
Thank you, Madam Chair and Representative Hansen. I was just wondering, judges are usually appointed and then run for election a couple or a few years down the road. I'm just wondering when the reporting would kick in, if it would not be until they officially file for election, or if it would be shortly after they're appointed.
Representative Hansen.
Thank you, Madam Chair. And Representative Moline, I know that was the concern we tried to resolve in the relating to the county commissioners, where the effective date, at least as this would go into effect, it would apply to those terms of office commencing after the next election. So I think in terms of if somebody was appointed between now and the next election, they would fill out the form, the economic interest form, when they filed for election. However, if after that date, and Mr. Goldsmith can correct me if I'm wrong, I think after that date they still would be, as they're brought in with appointment, need to fill that out rather than waiting until the next election.
Mr. Goldsmith.
Yes, Madam Chair, Representative, that's generally correct. Under the existing law, a judge running for office would file a statement at the time they file their affidavit of candidacy, as candidates all do, and a judge being appointed would file within 60 days after the date of appointment.
Representative Scott.
Thank you, Madam Chair. I'm just trying to see how this would play out in practicality. And so let's say a judge files their statement of economic interest. Is the Campaign Finance Board then, are they supposed to look at all the rulings that judges make to see if they've made a ruling that would be in conflict, or let's say they own stock in a particular company, and that's on the Campaign Finance Board, and that company comes before him, and he rules in favor of that company. Is that going to be immediately seen as a conflict, and is the Campaign Finance Board going to have to watch every decision that a judge makes in light of what they filed?
Mr. Goldsmith.
Madam Chair, Representative, no, the Campaign Finance Board does not monitor for conflicts of interest. It's a passive system where the financial interests are published, and it's up to the public and other interested persons to then determine, if the official doesn't determine on their own, for others to bring those matters before the board.
Representative Scott.
Thank you, Madam Chair. And so foreseeably, if a judge was brought, if someone from the public noticed this going on and they brought that forward to the Campaign Finance Board, there's a chance, and probably a really good chance, that they would also be brought in front of the Judicial Standards Board. Is that correct?
Mr. Goldsmith.
Madam Chair, Representative, I can't say for sure, but there certainly would be areas where the judge's obligation to act in an unbiased and impartial way in a matter would be a matter for the Judicial Standards Board, and might also trigger the requirement to file a notice of conflict of interest and then either abstain or have someone else handle the matter. I might add that the statute on what you do when you have a conflict of interest was never written with judges in mind, so it's quite unclear as to exactly what would happen. But potentially they could come before both the Judicial Standards Board and the Campaign Finance Board.
Thank you.
Representative Drazkowski.
Thank you, Madam Chair. Mr. Goldsmith, could the bill be amended to provide, I think, I'm not going to speak for Representative Hansen, but I like the bill. It seems to me that the intent of the bill is to provide daylight, to provide, public understanding of potential conflicts that could exist. Could the bill be amended so that if there was a complaint that came before the Campaign Finance Board upon someone realizing a potential conflict, could that conflict, potential conflict or that complaint then be somehow transferred to the Judicial Standards Board for them to act on so that you'd be relieved of that, what you perceive to be a duplication of efforts here?
Mr. Goldsmith.
Madam Chair, Representative Drazkowski, certainly that could be accomplished. It would seem to me that it would make more sense, though, to amend the law regarding the Judicial Standards Board and to require them to have primary jurisdiction over that, even if we had the responsibility for filing the statements and publishing the statements. That's something that we can do, but I would be fairly happy if we had an amendment that said any enforcement activity related to judicial conduct would go before the Judicial Standards Board rather than the Campaign Finance Board.
Representative Hansen.
Well, Madam Chair and Representative Drazkowski and Mr. Goldsmith, I'd be happy to work on this. I know we've got deadline, and maybe we can. I know you've got other bills on the schedule for today.
Well, Representative Hansen, I think that we're hearing that there might be some common ground here. Yeah. And so without your objection, I'd be happy to lay this over and then take it up next week to make sure you make deadline, but give you some time to work that out. Before we do that, is there anyone else in the audience who wishes to testify for or against this bill? All right. Seeing none, the chair lays over House File 136.
Thank you.
Thank you, Representative Hansen. Is Representative Atkins here? All right. Well, while we wait for Representative Hansen, then I'll present, if you'll chair, Representative Moline.
Representative Hilstrom moves House File 410 be recommended to pass and be sent to the General Register. Representative Hilstrom, do you want to present your bill?
Thank you, Madam Chair and members. Members, given the snow, my two testifiers are not going to be able to make it today. This bill comes out of a situation that happened in the Anoka County Attorney's Office. It was an incident where the charge in the criminal complaint was financial exploitation of a vulnerable adult. The vulnerable adult passed away prior to restitution being requested or restitution being ordered by the court. In this case, a stranger approached a vulnerable adult, befriended him, and ultimately the defendant was able to swindle or exploit $68,000 in cash, a Hummer, two $16,000 diamond rings, and guns from the victim in the case. The victim was, again, an older adult, and by the time the case came to resolution, the victim had passed away. There was a question in the law on whether or not the family could request restitution on behalf of the victim because the family was not out any money. The victim had enough money to pay for the funeral services, had money left in his estate, so the family wasn't out anything out of pocket. So it was not clear in the statute whether or not that family could request restitution. So the case in the Anoka County Attorney's Office went before the court and actually contacted Becky Perius to say, can you please help us figure out if the law is clear, if we need to have a change, and in fact learned that we probably could make it a little more clear. So that is what brings you this language. Basically, it just states that the family can bring a claim for restitution if the victim dies and it's not related to the crime. And with that, I would stand for questions.
Other questions from members? Representative Drazkowski.
Thank you, Madam Chair. Representative Hilstrom, I certainly like the bill. I'm just wondering, could there be an unintended consequence that there would be more creativity among pursuits of restitution, among situations where people pass away? I'm just thinking out loud here. Maybe that couldn't be an issue, but it strikes me that might be something that could develop. I don't know.
Well, Representative Drazkowski, this does not take away anyone else's rights. So if the victim is still alive in this case, a family member could not request restitution if the victim in the case was still alive. This is really for cases where the victim can't speak for themselves, to give the family the opportunity to request it.
Thank you.
Any other questions? Is there anyone here from the public to testify for or against the bill? Seeing none, I will renew Representative Hilstrom's motion that House File 410 be recommended to pass and be sent to the General Register. All those in favor signify by saying aye.
Aye.
All those opposed, motion prevails.
Thank you. At this point, we would entertain a motion to approve the minutes while we wait for Representative Atkins.
So moved.
Representative Bly moves the minutes. Any additions or corrections? All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Next is House File 482. This is Representative Atkins' bill, and it's my understanding that he is on his way. So I would move that House File 482 be recommended to pass and be sent to the General Register. And here comes Representative Atkins.
Blue jeans.
Representative Atkins, please go ahead.
Thank you, Madam Chair. I'm sorry, has the bill been moved?
It has, and the motion is to send it to the General Register.
That's a good spot for it, Madam Chair. Thank you, and my apologies for running a little bit behind. I've put off a few things the last couple weeks, and I'm now trying to catch up in a single day. But this is survivorship. 48 other states in the country have this law on the books, and I believe that was there a map placed in your folders this time along? Just the map itself is quite compelling. All states across the country, with the exception of Minnesota and Idaho, have a survivorship statute. And what that provides for, right now we have let me put it this way, we have a rather perverse disincentive for insurance companies to settle cases, particularly with elderly people. Because if they die, then the amount of damages that they owe their families goes down dramatically. And I mean dramatically, right down to just basically their costs if those people die. It's a very rare occasion when it occurs. In 21 years now of practicing law, I've never had it happen to any of my clients or their families. I think the fiscal note demonstrates that it's anticipated to happen about 2 times a year. But when it does, folks, it is one of the most devastating things that you can possibly imagine. You've got families that have been through all sorts of suffering, sometimes for many, many years. There's been the deepest and darkest of emotional trauma, physical pain that they've watched somebody go through. And all of a sudden, just because they pass away, the claim essentially is gone. And that's why 48 other states have already beaten Minnesota to this many long time ago. I honestly am not sure why we haven't adopted this in Minnesota, but it is long overdue. And with that, Madam Chair, I'd be happy to answer any questions, and I think there's also some folks who'd like to testify to it.
Questions from members? All right, seeing none, is there anyone in the audience who wishes to testify for or against this bill? Please please come forward, state your name for the record. Go ahead.
Thank you, Madam Chair and members. My name is Joel Carlson. I own a government affairs business here in St. Paul, and I'm here on behalf of the Minnesota Association for Justice. And some of our members have brought this issue to our attention, and to amplify Representative Atkins' point on how limited an instance this is. I think the fiscal note that's in your file is very telling. The Supreme Court fiscal note indicates that this may impact 2 cases a year. That we're talking about a very small number of cases where you have a wrongful death situation where those benefits that we hope will inure to the benefit of the family and their estate, which now cancel that death, we hope will continue, and all of our surrounding states, North Dakota, South Dakota, Iowa, Wisconsin, have this provision, and we hope the committee will favorably support it. Thank you, Madam Chair.
Thank you.
Happy to answer questions.
And members, you don't yet have the fiscal note because we didn't have the fiscal note, and so fiscal staff just went to get the fiscal note, but it's my understanding that it says 0.
There's no fiscal impact, and what is more telling is the Supreme Court's analysis of the number of personal injury cases, the number of cases where a personal representative is appointed. We're talking about 0.05% of the cases in the court right now on personal injury matters. It's 2 cases a year is what they indicate this would impact.
Representative Drazkowski. Oh, Scott. Representative Scott. Sorry about that.
That's okay. We get confused all the time.
He moved. I thought he had a question. Representative Scott.
Thank you, Madam Chair. We heard this bill in civil law, and my concern is that there's no cap on the damages. And you mentioned so many of the states have this law in place, but more than half of them have caps, and our surrounding states all have caps. So, is that something that you're open to exploring, Representative Atkins?
Representative Atkins.
Madam Chair and Representative Scott, with due respect, absolutely not. I don't think you should reward a wrongdoer by capping the amount that they would have to pay to an injured person. I just don't, in all seriousness, I don't think that's what we teach our children growing up. We teach folks to be responsible for their own actions. And if you let's say you cause $5 million in damage to somebody, there shouldn't be a cap of $100,000 or $300,000, particularly if you have insurance that will cover that on top of it. But I believe that we ought to be responsible for our own actions in this country.
Representative Scott.
So you believe there shouldn't be caps on any lawsuit at all?
Representative Atkins.
Madam Chair, personally, Representative Scott, you're exactly right.
Wow, okay.
Representative Scott. Questions from members? Seeing none. Representative Drazkowski.
Thank you, Madam Chair. Representative Atkins, I'm kind of shocked. You mean you were talking about personal responsibility. We just got done passing a government takeover of health care, and not to mention, we're going to have 35 or 40,000 more people on Medicaid.
Representative Drazkowski, we're in
I know, I'm sorry.
Judiciary.
I'm sorry, Madam.
Give them a roll.
Point well taken, Madam Chair.
Representative Drazkowski.
So what it looks like to me with this bill, Representative Atkins, is we're going to continue to sue people after they're dead. Is that what it does?
No.
Representative Atkins.
Madam Chair, Representative Drazkowski, no. It's the party that's been hurt. If they die, most of their damage is under current law, even though their family and others have suffered greatly with them. Right now, their damages go from typical damages down to next to nothing. And this would preserve some of those claims once they've passed away against the wrongdoer. Right now, we give the wrongdoer an incentive to not settle. If they're dealing with somebody who's 80 years old and poor health, it's actually to the wrongdoers, seriously, under Minnesota's current law, it's to their advantage to try to drag the litigation out as long as they possibly can, because if the hurt party, the injured party, dies, then the amount of damages that the wrongdoer has to pay actually goes down dramatically.
Representative Drazkowski.
Madam Chair?
Oh, Mr. Carlson.
Just to amplify that on Representative Drazkowski's question, not that we're suing people who are dead, but you may have caused the injury. Let's say, an automobile accident where a drunk driver has killed someone and also dies in that accident, your family would have a claim against that negligent driver for that conduct. So when you read on line 1.15, for or against a party, you could bring a claim in that situation against the negligent party for your damages, even though they were maybe deceased in the accident.
Representative Drazkowski.
Thank you, Madam Chair.
Other questions from members? Seeing none, the next testifier, please come to the table, state your name for the record, and go ahead.
Thanks.
Madam Chair, my name is Bill Hart, and I'm an attorney here in the Twin Cities, and I've practiced here for about 30 years, and I'm here today to offer some perspective, some things for the committee to consider and answer questions about this bill. I'm here to testify in opposition to the bill because, in my view, the policy underlying the bill runs counter to the purposes of a modern tort system, because the bill, as I read it, seems to allow someone other than the tort victim to recover the pain and suffering damages of the tort victim. And that's counter. Why do I say that's counter to a modern tort system? Because the purpose of recognizing torts in a modern tort system is to compensate people who have been harmed by someone else's negligence. When it comes to pain and suffering damages, and that's what this is about allowing someone other than the person who has suffered to collect those damages. When it comes to those kind of damages, no one suffers those damages other than the victim himself or herself. And so when we award damages in a tort action, the purpose of them and the amount of them, when a jury is instructed to award damages, the purpose and amount of those damages is meant to compensate that person during their lifetime. It's not meant to leave anything over for people to inherit. It's not meant to provide anything for other family members. Family members never recover someone's personal pain and suffering damages in a personal injury lawsuit. What this bill would do is allow, in these circumstances, that to occur. And the purpose of that does not seem to match what the purpose of having damages in a tort system is, and that's to compensate the person who suffered the damage. Now, the thing that I heard about this bill was that's very puzzling to me. This is only going to affect a couple of cases per year when a person dies of a cause unrelated to the tort that gave rise to the injury, and that's not at all how I read this bill. And I don't. The language that I see in this bill suggests that if there in any wrongful death action, the heirs and next of kin should be allowed to recover the pain and suffering that the victim endured prior to death, and that's just totally unprecedented in this state. And it runs, as I said, counter to everything we know about why we allow damages in the first place. So it's not limited to 2 cases per year as I read it. I understand the situation when someone, like an elderly person dies because they die of natural causes after, maybe they've had abuse or something like that. Those cases are different because they die of a cause unrelated to what gave rise to the lawsuit. But as I read this bill, it would apply, and it certainly will be argued to apply, to any wrongful death, every single wrongful death suit in this state. And now they're pointing to, the supporters of the bill have pointed to a map, and I can't agree with that map. I have looked at those states, and there are let's just say that there's nothing uniform about survival statutes in this country. There are many different flavors. It's not like this, there's one on this side and there's one on this side, and we're just one of two who are on the wrong side of this. When I looked at it, there were, and I just only had a chance to do this in the last 24 hours, there were many states who have a survival statute that expressly excludes the pain and suffering damages that we're talking about here. Arizona, Colorado, California are examples. Vermont's statute allows for survival only if the action is had been already commenced at the time of death. Now you say, well, how does that make any sense? That seems like a random factor. Because getting back to the fundamental premise that we're talking about here, which is the personal damages that have been suffered by an individual person, we don't allow other people to commence suit on behalf of people that choose not to. And so in a state like Vermont, they have decided that the person must show assent to bring a lawsuit before they die in order to allow someone to pick up where the suit left off. And there are many states, Alaska, Indiana, Missouri, Nevada, West Virginia, that only allow survival of actions when the death is unrelated to the tort. And if that's what this is, I would really like to hear someone say that's the intent of this statute, because as I read it, it says nothing in this chapter shall be construed as precluding the personal representative or successors in interest from pursuing a wrongful death action for all damages sustained before death pursuant to 573. So the notion that this only applies to a couple cases per year, that is not the way it's written.
Excuse me, Representative Cornish.
Well, I was actually just going to wait until you got done and I was interested in hearing Representative Atkins' rebuttal to this, and because Representative Atkins said that we're only one of two states, so I was just going to wait till he got done and hear Representative Atkins reiterate what he had said before. I was kind of confused. There seemed to be a complete disagreement on the number of states. So
complete disagreement.
Okay.
Complete disagreement.
Just a second. Go through the
Madam Chair.
All right. So, Mr. Hart, if you could just wrap up. Go ahead, Mr. Hart.
So, yes, thank you, Madam Chair. This would be a tremendous burden on the tort system because it will expand and complicate virtually every wrongful death action. It doesn't. It does not carry out the primary purpose that we have for a tort system, which is to compensate the people who've been injured, not to provide compensation to someone who hasn't been injured. That's what this tries to do, and there's really no policy underlying it other than just retribution for tort, which is not the purpose of our tort system.
Thank you.
In this day and age. Thank you, Madam Chair.
Thank you. Is there anyone else in the audience who wanted to testify on this proposal? All right, Representative Atkins, do you have a response at all? Or Representative Cornish wanted to know if you had a response. Representative Atkins.
Thank you, Madam Chair, and thank you, Representative Cornish, for the question. I actually would point you to the fiscal note. I didn't create the fiscal note. That's where we referenced the request in the last committee, actually I think by Chair Hilstrom, was to find out what the impact would be on our court system. So just so we're clear, it came from nonpartisan fiscal staff that their estimate was that it would apply to about 2 cases each year. And rather than take either the testifiers or my word for it, I'd prefer that you look to the nonpartisan staff for their analysis.
Representative Cornish.
That's fine with me. That's a good answer. Thank you.
Questions from members? Representative Scott.
Thank you, Madam Chair. I was just interested in your response to some of Mr. Hart's other statements that he made about other states, and maybe the map that you handed out was not as clear as maybe you would have us to have believed. So it sounds to me like all the states do something a little bit different, but this is more unprecedented than what the other states have. So I just wanted you to be able to respond to that.
Representative Atkins, before you do, I just want to make it clear, we did not get a map to pass out in this committee. The map that people were talking about was passed out in civil law. So the members here don't have a map.
Okay.
All
Well,
right.
I can, Madam Chair and Representative Scott, I can describe the map. It was all yellow, with
Representative
the
Atkins.
exception of two states that are, and it said each of these states has a survivorship statute, with the exception of Minnesota and Idaho. They have different versions. The version that we're proposing here is in fact relatively exactly the law in several of those states, but all of those states in one fashion or another have a survivorship statute, and Minnesota has none. And that was the point of the map, is we have no survivorship statute whatsoever.
Representative Scott.
Thank you, Madam Chair. Well, I just want to make sure we have the right survivorship statute. Would Mr. Hart care to respond to that?
Briefly, Mr. Hart.
Thank you, Madam Chair, Representative. The language in this statute is much broader than it's being represented to be. It's not applicable to just 2 cases per year. And that would be something that the staff would be very well advised to look at, because this has much broader application than what is being suggested by the minuscule effect that it's being claimed to have.
Well, I just want to make it really clear that the fiscal note is prepared through the judicial branch. So I would think that they would be analyzing accurately the impact they think it's going to have on the court, because they make us pay for stuff.
Sure.
So,
Madam Chair,
Mr. Hart, briefly.
It would be helpful then if the sponsor of the bill would say what the intent is, and whether the intent is to have this apply to wrongful death actions where the death is caused by the tort, as well as the situation that's been described, which is something completely different.
Thank you. Representative Johnson.
Madam Chair, Representative Atkins, in briefly reading the fiscal notice that they put in there, that it is difficult to estimate the impact this bill would have on the courts, which indicates some of the questions they may have as well as what was brought up here today. As I'm reading this, there are 389 traffic deaths in Minnesota in 2012. So that's 389 cases I believe could be brought up by this bill. I'm just wondering if you're amenable to a friendly amendment where this would apply only if the action or the tort was filed before the death.
Representative Atkins.
Madam Chair, thank you, Representative Johnson. Let me think on that a little bit. I'm not open to it right now just because it's popped out of thin air. I appreciate, though, the creative thinking, and we'll continue to think along those lines. And we'll look at what other states have done.
Representative Drazkowski.
Thank you, Madam Chair. Madam Chair, I'm wondering, could we lay the bill over until we think about it?
Representative Drazkowski, this bill, this bill's going to the general register? This bill's going to the general register. I'm not inclined to do that. I was fine with doing it on the other bill with the consent of the author, but unless Representative Atkins is looking forward to having his bill laid over, we have a very busy schedule coming in the next week, and it's certainly something that if we're limiting it, it isn't going to have a greater impact on the court. It would have a lesser impact on the court. Representative Drazkowski.
Thank you, Madam Chair. So, Representative Atkins, would you be amenable to an amendment like that from Representative Johnson on the floor?
Representative Atkins.
Madam Chair, Representative Drazkowski, I'll stand by my past comment, which is I'll take a look at it and see what impact it would have. And I appreciate, Madam Chair, the opportunity to pass out of the committee, because I'm not afraid with your busy schedule that we'd necessarily be able to find our way back on the agenda. But I will definitely look into the suggestion that was made.
Representative Pugh.
Thank you, Madam Chair. I just wanted to add this comment or share this comment aloud. Thank you to Representative Johnson for having brought that last point to our attention. In the third paragraph under assumptions on the second to last page of the fiscal note, it says the number of personal injury actions filed after the death of the injured person will increase as a result of this change in survivability. So I really do think this is an issue that should be addressed.
Other questions from members? Seeing none, Representative Atkins, any final words?
No, Madam Chair. Thank you for the input and appreciate member support.
With that, the chair renews her motion that House File 482 be recommended to pass and sent to the General Register. All those in favor signify by saying aye. Aye. Opposed?
No.
Motion prevails. Thank you, Representative Atkins.
Thank you, Madam.
Members, we had one bill that had to be removed from the agenda based on the weather. We'll be hearing that tomorrow. That will be added to the agenda. And with that, we are adjourned.